Welcome to Washington Legal Foundation's webinar. My name is Glenn Lammy. I am the Executive Director and head of our Legal Studies Division. And this is the first in a series of programs that we're doing in partnership with TechFreedom called Tech in the Courts. Tech in the Courts will examine key topics at the nexus of technology and law. And we really greatly appreciate the work that our partners have done to get this series off the ground. So Washington Legal Foundation, for those of you not familiar with us, we're a 501c3 organization that's been around since 1977. We seek to affect the way that the regulatory and legal system addresses free enterprise through litigation, through publications and programs such as this one, and our blog as well, the WLF Legal Pulse. TechFreedom is a nonprofit, nonpartisan technology think tank launched in 2011. The organization seeks to advance public policy that makes experimentation, entrepreneurship, and investment possible, and thus unleashes the ultimate resource, human ingenuity. There are few areas of law or regulation where freight carriers, internet service providers, and social media platforms find common ground, perhaps even if they shouldn't. Opinions certainly differ on the legal status of common carriage. In the Fifth Circuit's Net Choice versus Paxton opinion, Judge Oldham wrote how the concept was, quote, firmly rooted in our nation's constitutional tradition and arose from English courts applying this principle to numerous common callings like stagecoaches, barges, gristmills, and innkeepers. On the other hand, as one of our panelists today has written, stripping away the thin veneer of analogical folk law historicism reveals that common carriage is little more than a jurisprudential attractive nuisance. We're pleased to have with us today a group of legal thought leaders that have written, spoken on, and even enforced the concept of common carriage. I will briefly introduce them, and then we'll start the conversation. Berin Szóka, who will be joining us in a moment, is president of TechFreedom, also founded TechFreedom, named one of Washington, D.C.'s 500 most influential people by Washingtonian Magazine. His work focuses on how law shapes digital media in the U.S. and Europe, especially free expression, consumer and child protection, and telecommunications. Roger Nober is the director of GW Regulatory Studies Center and professor of practice at the Trachtenberg School at George Washington University Law School, a position he assumed in January 2024. He retired from BNSF Railway Company in December 2022, for which he served as executive vice president and chief legal officer. From 2022 to 2002 to 2006, Roger was chairman of the U.S. Surface Transportation Board. Ben Sperry, also joining us, is Senior Scholar of Innovation Policy at the International Center for Law and Economics. His research focuses on the intersection of civil liberties and government regulation, including the areas of online speech, platform regulation, and competition policy. On law school, we're proud to say that Ben served as a law clerk here at Washington Legal Foundation. And last but not least is Blake Reid, is an associate professor of law at the University of Colorado Law School. He researches and teaches in the areas of telecommunications, internet, copyright, and disability law. He also serves as faculty director at the Silicon Flatiron Center. His work has been or will be published in the Stanford Law Review, California Law Review, and the Indiana Law Journal. We're recording the program today. Just want to make sure you realize that. And if you have any questions for us, please put it in the Q&A function located in the Zoom webinar toolbar. TechFreedom is also going to be live tweeting during the program. The hashtag is #TechInTheCourts. So let's get started, Blake. In the line from your Stanford Law Review article that I read earlier, notwithstanding, what is common carriage and how does it impact government regulatory authority? You're on mute, Blake.
Thanks so much, Glenn. It's a pleasure to be here, and I really appreciate you organizing the conversation and inviting me. So I'll try and stay away from the controversy about what this is and give you the kind of stock understanding of what we mean. And I know we'll unpack it more as the discussion unfolds. I think it's helpful to distinguish common carriage rules, the set of obligations that we apply on common carriers, from the question of which kinds of firms, which kinds of industries we treat as common carriers. So I'll start with the rules, and then I know you've got another question about how we identify common carriers. But let me start with common carriage rules. So I think broadly speaking, we might describe common carriage rules as non-discrimination rules. The idea is we prevent primarily businesses from discriminating between different people and entities for the same service or the same class of service. We might have different classes of service within a particular business. And discrimination might come in different forms. It might come in the form of charging some people higher prices than others. It might come in the form of letting someone cut in line and go first, go ahead of someone else. Or it might be refusing to carry them at all. It might be a complete and total discrimination. So, common carriage, to the extent a coherent concept, I think is an obligation to treat all comers more or less the same within a given class of service. And I think we also find similar concepts in bodies of what we might call public utilities law, public accommodation law. There are other sort of related doctrines here. We might think about essential facilities in antitrust law. Okay, the tricky thing, and I'll talk just briefly about this, and then shut up, is that we have a lot of different regulatory regimes that we have called common carriage that date back many centuries. We see them applied to a lot of different industries. We see them applied to the transportation industry. So we have railroads, which Roger is going to talk about, ships and ports and trucking and tollways. We have public lodging, such as inns and hotels. And then we have the application of common carriage and what we've called quasi-common carriage doctrines to the information industry. So the telegraph and the telephone, cable, and the internet, which is where my expertise lies. And I think the tricky thing about trying to knit these things together is how we carry things, what we're carrying, and the modes of discrimination that might arise look pretty different when we're talking about a train. We're thinking about, well, what kinds of cargo, who does it come from, how fast does it get where it's going, that sort of thing. When we're talking about distributing messages on a social media network, or we're talking about listings that appear in search results on a search engine. And I think we end up seeing really different kinds of rules in different industries. And who makes decisions about what those rules are can vary pretty widely. Sometimes we specify the details a lot in a statute. Other times we defer to an agency like the Federal Communications Commission to say, in the statute, we bar unreasonable discrimination, but we leave up to the agency to sort of figure out what that means. So again, non-discrimination, broadly speaking, but the details matter a lot, and I think they depart. And look forward to getting into that today.
So it seems like common carrier status can arise from either being a certain type of entity or conducting a certain type of business, or even through formal law or regulation. Is it both? Is that a fair statement?
Yeah, so I'll just give my opinion on this. I think our common carrier status, the notion that you are a common carrier, I think that's just a designation that indicates a desire for the government to impose a non-discrimination regulation. So there are these tests that courts often will trot out and that scholars trot out. And I think the problem is almost none of them really hold up all that consistently in practice. So a really common one is, well, we apply common carrier status to everybody in the communications and transportation industries. The problem is that's just not true, right? There are lots of communications industries that we expressly don't apply common carriage or common carrier status to, such as broadcasters, for example. We have the perennial fight over whether internet service providers, in the context of net neutrality, are common carriers or not. We have the regulation, then subsequent deregulation of the airport, the airline industry in the context of transportation. So what kind of industry it is doesn't really hold. There's another notion which is holding out to serve the public. In other words, you say, I promise to serve everyone on all terms. The problem is we get into this like circularity there between the status and the rules, which is if you hold yourself out to the public, And you reinforce that by not discriminating against people, then you're a common carrier. But the second you start to discriminate and you say, actually, I'm going to differentiate between members of the public, then you're kind of no longer holding out anymore. And so your non-compliance with the rules also defeats the status. So that one doesn't hold up super well. Another one that we look to is market power, right? As a company have market power in sort of the antitrust sense of the term. Again, the problem here is we have lots of antitrust, for the purpose of antitrust monopolists that we don't treat as common carriers. And then we have lots of industries where we treat somebody as a common carrier who's not a monopolist. So again, that one doesn't hold up in practice. And then the last one that people often cite too is, are you affected with a public interest? And I think the trouble with that one is what the public interest means. There are not a lot of guidelines to that. And so again, when you say, yes, you're affected with a public interest, we're going to call you a common carrier. That's just saying we want to regulate you for some reason, and here's the kind of regulation we want to apply to you. I don't think that's doing a lot of work. I think at the end of the day, this is just a preference by legislatures to apply a non-discrimination regulation.
You mentioned transportation, obviously, Roger. If you could talk a little bit about the history of common carriage in the freight rail industry.
Well, sure. Excuse me. I would say that common carriage began what we think of as common carriage with the passage of the Interstate Commerce Act in 1887, which is, I think as Blake mentioned, the concept of being a government authorized carrier of the public goes back well before that. But what in the modern world we think of as being a common carrier, where you have obligations to the public to take whomever tenders you goods or people for that matter, take it on basically a non-discriminatory basis to make the rates that you're going to charge publicly available in a tariff that can be examined and that are there to be seen, and then with sanctions that are imposed by a government agency if you're unable to live up to those obligations. That really began in 1887 with the Interstate Commerce Act. And as I like to say about railroads, and I think there's a few railroad people on the webinar today, when you're looking at railroads, you're never far from history, and you really are starting with what are some of the historical reasons why these kinds of doctrines came to play. And in the freight rail industry, the idea of being a common carrier really sprang from the fact that before 1887, the most important person in any community from an economic standpoint was the station master, because he's the person who decided who got service and when they got service and on what terms. And that was prone to abuse, and that was prone to market manipulation. And so the original idea of being a common carrier was that you had to hold yourself out to serve everyone on terms that were publicly known, and you couldn't discriminate. Right, discrimination was a really important doctrine back in the beginning. It's less so now because it's become over the last 160 years so ingrained into the way we look at things. In more recent times, common carriage was recent being post World War I to passengers, and that's taken on a lot of different kinds of elements. First, it came to where you would serve them, who you couldn't discriminate against different individuals for whatever reason if they wanted to be on there, and then that also got applied to trucking. And what began to happen is over the probably 100 years from the 1880s to the 1970s, these doctrines became so rigid and inflexible that it became very difficult for transportation companies, particularly trucking companies and railroads, to compete. And while trucking companies seemed to do very well as an industry, they didn't do that well as individual entities. And so lots of trucking companies that were regulated did well through their regulated monopolies, but they didn't do that well once they were deregulated. And so what we saw was that then much of the freight rail industry was deregulated in the Staggers Act. And Glenn, I know you have some questions about that, which we will turn to. But I will stop there with saying that the original idea was to create a fairness and non-discrimination of service, although that concept is really known as being reasonable. And as I used to say as a regulator and then as a regulated entity, being reasonable and fair are not the same thing.
In the Staggers Act, Congress intended to increase the focus on private contracting while also retaining federal authority to require common carriage in limited situations. How has that worked out for both shippers and for the rail industry and for consumers in general?
Correct. Well, I mean, much of in the Staggers Act, Congress deregulated, important parts of the rail industry. It deregulated or greatly lessened the burdens to eliminating track and therefore service to individual carriers, which affected your common carrier rights. It was thought for a long time if you drop service to anybody, you were violating your common carrier obligation. You saw that a lot with, say, rural passenger rail service and rural bus service, where if those common carriers wanted to drop a particular town or go or kind of consolidate stops to larger ones, they would be fought as being violating their common carrier obligation. So much of what drove the deregulatory aspects of railroads was the ability to rationalize their service. And I used to note that when I was a railroad regulator, that if any of the railroad customers wanted to rationalize their product line by, say, dropping the 10% least profitable parts of their business line, they could just do it. They wouldn't have to ask. But freight rail, because it's regulated and because they're common carriers, would have to get specific ability to change those services. So what the Staggers Act did was allow for railroads to individually contract with shippers, and that let them discriminate. It's a word I don't like, a loaded word, but it allowed them to demand price, to charge some less and some more, and not have to charge roughly the same price for the same service at the same passenger mile. And airlines were able to do the same thing. You see it now if you ever play the game of go up and down the rows of a plane and see who paid what for their plane ticket. You'll find radically different amounts, and you might find that in railroads as well, depending on where the individual shipper stood. That has rankled the customer base ever since, but it's allowed railroads to be able to maximize their revenue. It's allowed them to not be strictly beholden to, absolute charging the exact same person, the exact same thing in the exact same circumstance, and instead be able to respond to market conditions, which is when you're a market participant, what you have to be able to do.
So let's move in a direction where common carriage becomes a little fuzzier. Berin, in TechFreedom's Supreme Court amicus briefs in the Moody and Paxton cases, which made reference to that, one came from the Fifth Circuit, one came from the 11th Circuit, and the court heard arguments in them separately, but they ended up with a decision in one. It states that common carriage, quote, involves the transportation of people and commodities. What about telegraphy and telephony?
Yeah, those services are involved in transmission, which is the analog to transportation, right? It's the same idea of carrying A from point B to point C. That's what common carriers do, whether they're involved in a physical commodity or some kind of communications service. And I would just supplement what Blake said by noting that the courts have been very clear about this. Whether you are a common carrier is dependent on the service you're providing. It's not really about you as the provider. It's what is the nature of the service. So if you hear us talk about whether someone is a common carrier, we're talking about whether a particular service is a common carrier service. So that's function one. Function two, Roger was alluding to, which is what does it mean to be a common carrier? How does the agency that's charged with regulating you apply common carriage duties? And he noted that those have changed over time. Congress may change them, the agency may change them. Some of the debate that we've had about Title II regulation, which is the common carrier provision of the Communications Act, is about both things, whether broadband providers should be considered common carriers, and if they are, what provisions of the original Communications Act should apply to them. But to answer your question, Glenn, what is the core question in the Communications Act is, are you providing transmission? If you're providing raw transmission and nothing else, you are providing a common carrier service. So the classic examples of that in communications land were telegraphy, and telephony. So that Congress said so in the 1910 Mann-Elkins Act, and those were imported and moved over to the Federal Communications Commission in 1934. And to make a very long, very painful story short, the FCC spent several decades in what it called its computer inquiries, trying to distinguish between basic and enhanced service. So that was the basic service was basic telephony, and the enhanced service was all the data processing services that were provided on top of that as digital remote processing became a thing in the very early days of telecommunications, and then with the emergence of the internet in the 1980s. And essentially what the FCC said was, if it really is just transmission, common carrier, if it's anything else, if it involves data processing, it's not a common carrier service. Congress took those ideas and put them into the 1996 update to the Communications Act, which was the Telecommunications Act. The FCC was asked by Congress how to interpret those terms. In 1998, the FCC said this has been a matter of great debate. It's been highly contentious. We've been dealing with this for decades in the computer inquiries. Hard to say, but at least some broadband or internet access provision is not a common carrier service. It's what the Communications Act in its updated form calls an information service. And thereafter, the FCC has spent the next 26 years trying to figure out how to apply that. And to summarize briefly, in a series of rulemakings in 2002 and 2005, they said that broadband internet access service was not a common carrier. It was instead an information service. That went up to the Supreme Court. The Supreme Court in 2005, in a decision we'll talk about called Brand X, agreed, all the justices agreed, that while there was some transmission involved, that the nature of what was being provided and what was being offered to Blake's framing was ambiguous. And they deferred to the FCC when the FCC said that because it was ambiguous, that it had to be an information service because it involved both data processing and transmission. And the FCC has now gone back and forth on that. And that's what we're fighting over with respect to broadband.
So yeah, that's definitely the decades game of ping pong that we've seen on Title I versus Title II. So as a matter of statutory interpretation and practically, how are ISPs different from basic telephony?
Well, we perhaps don't want to get too deeply into this. You can read Brand X if you're interested. But the short answer is that what they provide involves, as I said, a mix of data processing and transmission. It is not purely taking data from point A to point B. And that's part of what's now in litigation. Back in 2000, the early 2000s, when this was litigated, there were a bunch of other services that were included along with broadband internet access service, and that would include things like the way that your computer resolves requests on the internet. It doesn't actually go to the website name that you type in. It actually goes to an IP address, and there's a whole system behind that matches domain names to IP addresses. That's one way in which there's processing involved. And that's something the FCC now says, well, that's optional. The FCC now says this is a pure transmission service. I'll just put my cards on the table and say, I think it would have been hard before the recent Supreme Court decisions for the FCC to win its case. I think it's now impossible because what the court said in Nober, we had a question about that, was that it was the job of the courts to decide on what the best meaning of the statute was. It would allow previous decisions that turned on Chevron to remain in place. So Brand X, which turned on Chevron, remains in place. Brand X said both that the Communications Act is ambiguous, which that's still true. And if it's ambiguous and there's a major question involved, then the agency can't decide that question. But also, Loper-Bright said that the all decisions previously turning on Chevron remain in place. Brand X remains in place. Brand X said the Communications Act can be interpreted to recognize broadband as an an information service. So that's a non-common carrier. So that also remains in place. So I think the FCC has a very, very hard task ahead of it in trying to distinguish its rationale from what the court said previously. And I would note that of these almost 600 paragraphs in the order, exactly 7 of them actually discuss this issue. So really, you don't learn all that much by reading the FCC's order. You have to look at the briefs that have been filed. And we will get an answer soon enough.
Thanks, Berin. Ben, what if somehow the Title II categorization would survive for ISPs, what would the impact be on not only just the ISPs, but the larger internet ecosystem, both from an economic standpoint and a practical standpoint?
Yes, first, thank you for inviting me to be here. It's an honor. My first job while I was in law school that wasn't on the farm was working for Washington Legal Foundation one summer as an intern. And my first job out of law school, at least one of them, I was with TechFreedom. So hopefully I do everybody proud here today. But to answer your question, much as Berin kind of went over the history, I mean, since the rise of the commercial internet in the 90s, the regulatory approach to broadband regulation in the United States has been relatively hands-off, and that was an intentional choice by Congress and the regulators. And this approach was more or less maintained by the FCC for all but 3 of those years when, between 2015 and 2018, the Commission reclassified broadband access as a telecommunications service. And I would note, under that light touch Title I approach, the marketplace for broadband in the U.S. is competitive, dynamic, and generally serves consumers well. Since 2018, when they went back to a Title I approach, more households have been connected to the internet, broadband speeds have increased, prices have fallen, and more households are served by multiple providers. New technologies like satellite and 5G have expanded internet access and even intermodal competition among providers. Even FCC's own data, using the newer definition for what classifies as high-speed broadband, shows 91% of Americans have access to it. All this together, I think, would be pretty strong evidence that the current regulatory approach has worked pretty well. On the other hand, there is data and evidence that suggests Title II reclassification could have negative impacts on investment and innovation. Whether we look at this because of the so-called bright line rules that kind of say that all revenue has to be raised from just one side of the market, i.e. those broadband users, or we look at the broader impacts of Title II reclassification, which involves regulatory uncertainty through like the general conduct rule, and even Section 214 license authority. This regulatory uncertainty will most likely reduce investment incentives. Multiple studies have argued that there was lower investment in the lead up due to Title II reclassification the last time around. George Ford had a pretty good econometric paper on this from 2018. But the best empirical analysis I've seen in the last few years comes from the European Journal of Law and Economics. A number of economists compared the approaches of all the OECD countries, and they concluded that net neutrality exerts a negative impact on fiber investment. That's what they focused on. And this empirical result indicates that strict network neutrality regulations slow down investment in fiber-based broadband connections, and thus also indirectly impact subscriptions from consumers. And it's kind of been noted to some degree by Berin in his answer on the history. The move to Title II under these circumstances really expands the authority of the FCC to solve a problem which arguably doesn't really exist. There wasn't a lot of evidence adduced that in the meantime, when it was last classified as a Title I service till now, that there was a lot of new problems that arose. A lot of the things the FCC pointed to was national security concerns, public safety concerns, privacy concerns that Title II is supposedly necessary for, even though the FCC is not really the expert agency in any of those areas. And then furthermore, they had to make Title II work, so to speak, when applied to broadband by forbearing from a bunch of provisions. But even with just what it kept, the FCC's retained immense authority to regulate nearly every aspect of broadband. It goes way beyond even traditional common carriage concerns in some ways. The general conduct rule in Section 240, authority over licenses, gives them a lot of authority to declare practices illegal or hold up mergers through that licensing authority. This may push a lot of providers to get pre-approval from the FCC under the advisory opinion process they outline in the order, which could transform the FCC with this Title II authority into, in some ways, a central planner for things involving broadband. This is sure to dampen investment incentives. So I think that's probably the biggest impact that you'll see if this categorization is upheld.
So Roger, for those that need to act as common carriers under the Staggers Act, as compared to Title II, which really doesn't have any kind of protections, what kind of safeguards exist when rail carriers do have to take on those kinds of responsibilities?
Well, the Staggers Act recognized that just acting the regulatory scheme overseeing railroads wasn't working. And so what it did was it put in a number of factors that in addition to deregulating the industry for rates and services and the ability to contract, it also put in safeguards for how the regulator was supposed to look at it. I would back up by saying that railroads are a little different from some of the other industries that you've talked about. And one of the things that makes it very hard to really have an apples to apples comparison to railroads is that a lot of the different kinds of common carriers have multiple lines of business that are a little more distinct. Railroads on the same track have a mixture of both regulated and deregulated business. So that's what the Staggers Act did. It allowed it to contract, which essentially became deregulated business, and it allowed the agency to exempt certain kinds of carriage that had competition from regulation, and at the same time maintained common carrier regulation and common carrier obligations for regulated traffic. And over time, the balance between regulated and unregulated has changed some, but with the decline of coal and the rise of intermodal, it's probably more like 60 or 70 to 30 these days. That's a swag. My railroad attendees may give me some coaching on whether I got that wrong, but I think that's probably pretty right. And what it did was to say for those remaining regulated commodities, there is a common carrier obligation, and how much that applies to deregulated or exempt traffic is an unanswered question right now. And then secondly, and importantly, it applies to rates, but it says that those rates have to be reasonable. And when it looks at whether you're providing common carrier service or whether your rates are reasonable, there were a number of factors that the Congress gave the agency to look at. And the rail transportation policy is what they're called. And they have a mix of different kinds of things. Everything that you could possibly imagine is something that's there. But principally, in the way the agency has implemented them, they have said it has to help the industry achieve adequate revenues, because the industry was going bankrupt and it had to have adequate revenues to be able to reinvest. And that emphasis by the agency over the past 40 plus years has allowed the industry to really thrive and become financially sound and healthy. It's provided a little bit of, at this point, some controversy as to whether the industry's become too profitable and to whether or not what does adequate revenues mean. That's never really been defined. But it does, I think, that to one of the questions that came in from Olivier about what will the Loper Bright decision do. You have had a lot of regulators who've looked at the profitability and looked at the rail transportation policies and say, you know what, the way the agency has weighted these over the last 45 years is wrong, and we want to alter them. And I think those kinds of exercises are going to be more difficult to do, to say, I'm a populist now and I want to reweight these and give less to one and more to the other. It's not going to be impossible, but it's going to be much harder to do given the history of that agency and the way that they've implemented decision after decision. And now some of the public statements that have been made. But that's my personal opinion.
So before we move on to another application, Blake, wanted to give you an opportunity to offer some thoughts on the issue of ISPs and whether they're more information service than basic telephony.
Yeah, I want to pick up with what Berin mentioned about the computer inquiries because I think it's a helpful frame. The idea back when mainframe computing was coming into vogue, that we would have a basic communications network that would serve as a sort of foundation, sort of a platform for interesting generative activities, and that, in those days, sort of mainframe computing, and that we would regulate and think about the kind of, common carriage and consumer protection obligations, like the privacy of competitive data and that kind of thing, that we would have some regulatory oversight at that foundational layer, but the FCC wouldn't have a lot of involvement further up. I think that's a pretty useful conceptual idea, and I think that's pretty well embedded in the definitions in the Communications Act. I think if you look at the definition of telecommunications service, you don't actually find any reference to the phone system specifically. You have this pretty neutral, no, tech neutral notion of the offering of telecommunications for a fee directly to the public, regardless of the facilities used, right? And so I think where we went awry is in the early days of the commercial internet, we were using pre-existing networks. We were using the phone system with dial-up internet access. We were then using the cable television network to provide internet access. And there was sort of a notion in those days that, well, we've got that foundational layer as this old legacy network, and the internet is this new thing that rides over the top. But I think in the last 25 years, we've come to a pretty different understanding of that. And the basic thing that we all, purchase, by which we're having this conversation today, is that sort of foundation of internet access. And then we have this application layer that sits across the top, and we get to use things like video conferencing services and email and browse the web and video streaming and all of that. Um, and so I think the unfortunate thing about where this is going to go, and I agree with much of what Berin said about the difficulty that the FCC is going to face sustaining these rules. And I actually think, to the point that was raised in the chat, I think it's less Loper Bright, and I think it's more the major questions doctrine. I think the really unfortunate thing about the major questions doctrine is, and the way the Sixth Circuit has applied this to the net neutrality analysis, it says, no, we actually don't want tech neutral regulations. We need Congress to speak really specifically to the thing that it says. And I think Congress was trying to be fairly flexible and fairly forward looking in 1996. And now the Sixth Circuit has said, well, because it doesn't refer specifically to internet service providers there, we assume that Congress didn't mean that. That's tough to overcome. And I think it is worth thinking about, just to respond very shorthandedly to what Ben had to say about this, to think about where we've actually been for the last 25 years and where we might go now. And I think there's a profound change in the following way. I think for about the first decade or so, or at least maybe the first 5 years of the commercial internet, there's a pretty strong tacit understanding among the internet service providers of the day and the sort of budding application platforms of the day that we were going to have kind of a neutral internet, right? Not one that was enforced by really specific regulation, but there was an understanding that there wasn't going to be discrimination on the basis of application. The idea was we're turning the phone system inside out, and rather than having to go ask AT&T for permission to do something innovative, you just roll it out, hook your computer up to the network, and go. And then we started to see ISPs that had these legacy services like telephony and video see threats emerge to those legacy businesses and start interfering with them. And then we actually saw the FCC in ways that were not, Title II, but under Michael Powell's stead, saying, "Hey, knock it off, guys! The for freedom speech. People are using the internet, have the freedom to access the applications that they want. Stop discriminating." And then when ISPs started to push the envelope, the FCC responded and kept responding in increasingly aggressive ways. And then we've gotten into this sort of back and forth about whether Title II applies. But I think we've lived the first 25 years of the commercial internet under this kind of Damoclean sword, which is we've never had robust net neutrality rules that have stuck for a really long period of time, but we've always had the threat of net neutrality right around the corner. And by the way, I think, I'm sorry, Ben, but I totally disagree with just about everything you have to say about investment. I think if ISPs are being honest, like the threat of net neutrality regulation has been there since day one. I think the odds that that's a driver of investment is a little silly. But I think what we face now is we actually have for the first time the possibility that there really isn't going to be net neutrality regulation. Maybe the states will step in and do something, but Congress, it's going to be really hard for Congress to come around the pike on this. And ISPs have always been constrained in coming up with interesting and profitable ways to discriminate. And that actually requires some talent and some innovation to do that. And ISPs don't face a lot of competitive pressure to build up that talent, but suddenly they are going to see a longer runway in front of them. And so I think we might see more aggressive, more creative efforts to build sort of vertical ties into what ISPs are doing and build sort of deals into the application layer that are going to be really pernicious, that are going to hurt consumers in terms of price, that are going to hurt consumers in terms of privacy, are going to have deleterious effects on public safety and all of that kind of stuff. We shall see, right? But I think that's where we're headed, and I think that's really pretty different than where we have been any time in the early history of the internet.
Thanks, Blake. So let's move up the tech stack to the application layer. Ben, the state of Ohio wants to regulate Google's search engine, and as many others want to, it seems, and is thus arguing in court that Google's a common carrier. What's their rationale to that, and why do you think that doesn't really work?
Yeah, sorry. I wanted to make sure I wasn't muting myself still. The major elements that are generally agreed to in the common law are for an entity to be a common carrier, it must hold itself out to the public to serve it indifferently by carrying goods or persons to the extent of its capacity in exchange for some kind of benefit. Ohio argues that Google is a common carrier of information. In the view of Ohio, Google holds itself out to the public to carry information in response to search queries to anyone who asks, or indifferently, according to the current terms of service, while benefiting from user data for its advertising network. Google responds that they don't really carry information at all. That's really the job of the ISPs. What they do is they offer a curated response to queries that serve as their opinion the best answer, which is then carried by ISPs. Just vastly simplify how it all works to those users. Google also argues, somewhat unconvincingly, in my opinion, that it doesn't get paid directly by those users. It does receive a benefit, so I think it's a little bit unconvincing, even if they do receive those answers for free. I think Google's best point is that it doesn't really offer an undifferentiated service or serve the public indifferently. The answers it provides just to users, for instance, can be different from person to person based upon location and search history, as well as other factors, even if it's the exact same query. But moreover, I think the common carrier argument here is kind of odd in a way. The argument on its face seems to be about whether Google holds itself out of the public to answer questions, but the non-discrimination requirement sought by Ohio is on the search results side. It's not really kicking off any user, that is Google, from using its service. What they want is Google to not self-preference in its answers. But there's no clear reason to believe that Google's users don't use its product precisely because of some degree of self-preferencing. Many users may actually prefer to use Google because of its integration with Google Maps and its reviews and its shopping and flight products. Competition, when it is easy to switch between search engines, whether vertical or general, seems to me would limit the amount of self-preferencing insofar as users didn't like it. What's particularly odd is that Ohio asserts Google's dominance is tied up in its being the best search engine. But if the reason they are the best is because users prefer it, then it raises the question, to what degree do they prefer it because of self-preferencing that Google does? For instance, in the EU, there's no longer integration between Google Search product and Google Maps due to the Digital Markets Act. But many users in Europe have raised the question, are we even better off?
So who else other than the Ohio Attorney General is pushing this concept that web application and social media platforms are common carriers?
Yeah, so the common carrier status argument for social media and even email to some degree has been pushed primarily by some conservatives in different places, both nationally and at the state level, who have alleged bias by big tech companies against conservative voices. Florida and Texas both passed laws that were recently reviewed by the Supreme Court in the net choice cases that were dealing with such bias on social media platforms. And then Commissioners Carr and Symington, the two Republicans at the FCC, also wrote a journal article arguing that common carriage-like requirements should apply to social media. I would note, though, that common carriage-like remedies have also been pushed by both progressives and conservatives against app stores, arguing Apple and Android should be able to preference their own apps there, and even against Amazon and Apple when it comes to using data from their platforms users to create competing products.
So, Berin, it's interesting that some of the people that Ben mentioned have publicly opposed Title II status for ISPs. How can they be in favor of categorizing web applications as common carriers but not ISPs?
Well, some of them don't know any better. They just don't understand the subject that we're talking about. Some of them do. Some of them might be FCC commissioners, might be telecom lawyers, and understand very well what makes something a common carrier, and they just don't care because this is not about substance, this is about politics. And they have decided that this is a winning issue for them. It might make them chair in another Republican FCC or whatever, because the telecom analysis here is really simple. So Ben and at the outset, Blake noted a number of things that people have said over the years might make you a common carrier. I noted that in the FCC's case, it's about whether you're involved in transmission versus processing. We haven't yet talked about the First Amendment. This question has already been litigated because when the FCC's 2015 order was challenged, it was upheld by a panel of the DC Circuit that went up to the en banc DC Circuit. Judge Kavanaugh argued that the net neutrality rules, the no blocking, the no throttling rules, that is not just the Title II status, that those violated the First Amendment rights of broadband providers. And the two judges who had upheld the order in the panel below said, oh, but look, the definition of broadband internet access service, which is all that's covered by the rules, it's not all broadband, it's just that's that bias service. The definition of bias includes only those services that hold themselves out as offering connectivity to all or substantially all endpoints. And so, to return to Blake's original point, they said, the judges who took the FCC side, if a broadband provider made clear, and they set aside exactly how that would work, but if they made sufficiently clear, let's say in advance, that they were offering a curated service, that wouldn't be bias. It wouldn't be covered by the FCC's open internet rules, either the 2010 rules or the 2015 rules. And for that reason, said these two judges, the First Amendment is simply not implicated because any service provider that wants to exercise its First Amendment right to curate a service can readily do so, and by doing so, would opt out of the rules. So we know that that's essentially the First Amendment analysis here. That hasn't been litigated, but they wrote a very thoughtful opinion. Judge Kavanaugh seemed to think there was still a First Amendment issue. But that is the state of the law today. And if you take that and you map that onto so-called tech companies, social media, search engines, and so on, the answer is very clear, and it's the same answer that any First Amendment lawyer would arrive at, which is if what you were doing is processing, that is curating, making recommendations, discriminating between one website and another, which is what search engines do, if you're doing those things, you're processing, you're engaging in editorial judgment, you're exercising your First Amendment rights, you can't possibly be a common carrier. You're not doing transportation or transmission. This is not hard. The people who should understand this, the people who have been on the other side of this debate, persist in arguing that somehow internet service providers, that the broadband providers, aren't common carriers, but somehow the tech companies are, for the simple reason that they don't like the tech companies, and they think the tech companies are being mean to them. And as Blake said, that is, there are several possible positions that one could take in this debate, but that is the one position that makes no sense whatsoever.
Blake, you did quite a bit of analysis in your Stanford Law piece in this sort of realm, so I wanted to give you a chance to offer some thoughts there too.
Yeah, let me just slightly disagree with one thing Berin said, and then mostly agree with everything else that he said, which is, I think the FCC and the non-Judge Kavanaugh justices that wrote on this in the DC Circuit in analyzing the First Amendment implications of what ISPs are doing, very rightly pointed the fact that all of the ISPs vociferously purport to endorse net neutrality. They say so on their websites. They come in and represent as much in court, and that you couple that with, I think there's a little bit of sort of wiggle room the FCC tried to build in terms of access to substantially all the internet, to say, look, you're really trying to provide access to the whole internet, and you don't get out of that just because you've got a 0 rating deal for Spotify or something like that. And I think one other important piece of common carriage regulation is that we often impose some kind of entry and exit restrictions, so that if you decide to change and people are relying on you as a common carrier, you don't just up and say one day like, oh, I'm out of here. I'm no longer a common carrier. I'm going to rug pull from all my carriers. You have to unwind that. You have to give up the public benefits to which you've become entitled as a result of being a common carrier. And we manage the process of that transition. So I don't think it's quite so much like ISPs get to start, if they were subject to common carriage rules, that they could just sort of nope out of it by saying, we're not common carriers anymore. I think there's a management to the process. But I totally agree with everything that Berin had to say about the inconsistency with opposition to net neutrality rules from folks that are endorsing applying common carriage-like rules further up the stack. And I think whether you're thinking about competition concerns, which is what I think motivates a lot of folks, or you're thinking about speech concerns, whatever argument that you have that the application layer platforms have either too much economic power, don't face enough competition, or don't have speech rights, those arguments apply with equal, or I would argue much greater force to internet service providers. And so, Berin and I often disagree about the right thing to do about ISPs, but I think the idea of flipping it around and saying, oh, ISP is not common carriers, but Google is, or Facebook is, don't make a lot of sense. And in particular, I think about Google, I think Google is literally a discrimination engine, right? A search engine is literally designed to discriminate on the basis of search. That's something that's just fundamentally different than what an ISP does, or what a train does, to Roger's comments, or to any other sort of traditional common carrier that we can think of. That doesn't mean we can't check economic power, but kind of conflating those things and saying, well, it doesn't, we don't need to account for the fact that a search engine is literally built to do discrimination, or that a social media platform has to do some inherent curation just to make decisions about what order things show up in. We got to deal with those specifics, and I fully agree with what Berin has to say on that front.
I want to wrap up on the applications, but real quick, Berin, what should we be looking for now that the Moody and the Paxton case have been sent back down to the 5th and 11th circuits, respectively, with regards to the First Amendment and common carriage?
Well, I think we know what's going to happen. The dissent, well, it's called a concurrence because, of course, everyone agreed that the case should be sent back to the appeals courts. But the three conservatives, far-right conservatives on the court, clearly tried to sketch out what the lower courts should do. I think the Fifth Circuit will take them up on that argument. And in particular, they will argue that, in fact, these are common carriers, and their opinion will turn heavily on that. And so we will have to get the Supreme Court's take on why calling something a common carrier doesn't make it so. It doesn't deny the services of First Amendment rights, because common carriage regulation, after all, is a form of economic regulation. You can apply economic regulation to business conduct. You can't apply it to the exercise of editorial judgment. And we're going to have another round of litigation in which that will be hashed out. You can read TechFreedom's briefs on this point. We have been making this point at every stage throughout both litigations. We will continue to make this point. And I will just note, we have made one other point, which is that if these were common carriers, the task of content moderation would become quite difficult because, yes, common carriers do have the right to remove people for being obnoxious and disorderly and disruptive and profane and so on and so forth. But they have to justify all their decisions, and they have to be reasonable as to how they make those decisions. And that works when you're talking about whether you eject someone from a railroad car and you have a list of words you don't want them to say and a list of abusive behavior that will get them kicked out. That does not scale to content moderation at the scale of the internet. It's simply not workable. It's impossible to do content moderation online consistently at scale. That's Masnick's impossibility theorem. I think he's quite right about that. But for some people, that's the point of calling these common carriers. They want to break content moderation because they think that content moderation equals censorship, and they want certain kinds of content online to succeed because they benefit from it politically. That is the backdrop for why we are having this debate and why we can't have rational, consistent thinking about what is and is not a common carrier service.
Thanks, Berin. I know Berin needs to run. Thanks for being with us today. Let's circle back to where we got started. So we've talked about how certain government actors are trying to expand the concept of common carriage and use it for a tool for government control. That's now happening in freight rail, where common carriage is an accepted practice. Roger, can you talk a little bit about the Surface Transportation Board's recent ruling involving coal transport and its potential implications?
I'd be happy to, Glenn. I'll have to start with full disclosure that I was still at BNSF when this matter started, and so I'm not a completely unbiased viewpoint on it. But I will say that, just by way of background, what happened here: a coal exporter who happened to be a Native American tribe was sort of frustrated that they weren't able to ramp up and down their export capacity when they wanted to. And there was back and forth about what, and they were on a long-term contract, and they wanted to be able to, have, and through their contract, be able to ship varying amounts. And for railroads in particular, where you're capacity constrained, great variability in volumes is very challenging. You have to have the right amount of, it's not like, it's not an industry that has a lot of excess capacity in it. And so there was a lot of frustration. They weren't able to get the amount of service that they wanted, and they went and filed a complaint at the Surface Transportation Board saying that by not being able to provide the highest amount that they were looking for, the BNSF, which is one of the nation's largest freight railroad by volume, was violating its common carrier obligation. And the agency, taking a really outcome-oriented approach, didn't just look at the question of what it means to be a common carrier. It went in and examined the contract negotiations back and forth between the carrier and the shipping entity to say, well, you might have offered this or you might have offered that. And because it saw in a confidential contract back and forth an amount, said that you're legally obligated to provide it because you offered it. And I mean, that as policy is absolutely horrible, because first of all, it's one thing to offer an amount of capacity where it's guaranteed and locked in with a take or pay, so that if you then invest to the capacity to be able to handle that plus all the other traffic, you're able to do it. That's why railroads look for kind of assured amounts and guaranteed minimums, because they'll have to invest in locomotives, they'll have to invest in track and in people to be able to handle those volumes, plus what everybody else brings in. And at the same time, by asking them to do this without having any commitment of that carrier to provide an amount, saying your common carrier obligation is the most they could ever think of, then that would basically impact all of the other shippers on the line, because what the capacity they had would have to go to this shipper if they wanted it. A good analogy is what happens, and I was making this point earlier, I probably didn't make it very clearly, that railroads are only partially regulated from a rate standpoint, not necessarily from common carrier obligation. And if you're a utility and the utility in, say, Texas says, you know what, we want there to be enough electric generation so that on the 10 hottest days and the 10 coldest days of the year, we're going to be able to turn on that last incremental bit of generation capacity and handle the absolute peaks, then a utility that builds the power plants that maybe only are used 5% or 10% of the time, they're going to give them a full return on their investment plus a profit for that. And all of the ratepayers pay that extra amount because it's in their interest to have excess capacity. The STB, which is the rail regulator, saying, you know what, we want railroads to maintain excess capacity, but because 2/3 or 3/4 of their freight is not regulated, they can't require people to pay for it. So essentially, railroad owners have to be the ones to provide excess capacity, and that's just really a backwards way of looking at it, and it arguably could make the situation worse than it was before 1980 that led to the Staggers Act, because at least then everything was regulated, and to charge all the customers enough to be able to have excess capacity nearly bankrupted the industry. But now to require that the owners to do it will drain capital out of it, and I was strongly against it. And fortunately, well, I won't say fortunately, the matter was able to be resolved. And Glenn, I know your organization put something in, and hopefully now the political makeup of that agency has changed, so we won't be seeing more just really horrible results like that. And they can quote me.
So the
They
STB
won't be
was
surprised.
actually
The agency won't be surprised that I said that.
no, I'm sure not. STB was actually asked to vacate its decision once the settlement came down, and they outright refused to do that. Were you surprised by that?
I was actually. I was. I will just say in general, and this is not in specific, regulators who are more interested in media coverage than regulating tend to make decisions that are not always as durable. And, my advice now that I'm a student of regulatory process, my interest is in seeing regulatory decisions and regulatory doctrines that are transparent and that are durable. And being political outcomes, and I think we've heard this on the telecommunication side, are not durable. They're not something that provides a steady regulatory environment that private entities can live and thrive in. And I think that's a really good parallel between the telecommunication space and the physical space.
So Blake, I want to give you the final word here. You write in Uncommon Carriage, quote, as with the scope of common carriers, legal scholars, policymakers, and courts again appear to lack any meaningful consensus on limiting principles for a coherent body of common carriage rules. Why is that so critical that there be limiting principles around this concept?
Thanks, Glenn, for letting me close it out. And I hope you'll indulge me in just responding quickly to the last thing that Roger said, which I think is really interesting. Roger, you made a point about capacity, and there being real capacity constraints in the railroad industry. And I think the interesting thing about in the telecommunications context is 20 years ago, I think a lot of our conversation was driven by concerns about capacity and congestion and how to factor discrimination into the management of networks. And networks have evolved a tremendous amount in the last 20 years, and the capacity issues look really different. And now we have to deal with capacity in things like private transit and the provision of denial of service prevention services and that sort of thing. So our inability to get out of the sort of net neutrality starting blocks with the sort of back and forth that we've had have prevented us from kind of keeping pace with the sort of questions about capacity that it sounds like are afoot in the railroad industry. All right, sorry, Glenn. Thank you for the indulgence. I get to your question. So I think the need for meaningful sort of principles here is really important because for two reasons. building on what Berin said earlier about, we're talking about specific services and specific functionality. We're not just making categorical judgments about the entire internet industry, which is just really like the entire economy right now. It doesn't make sense to make judgments at that level of abstraction. I think, and I support a lot of the ideas underlying common carriage regulation. I think it's about checking economic power. It's about ensuring competition. It can be about preventing pernicious discrimination that we don't like, and I think there are good reasons for that. But we need to actually do the hard work of attending how those principles in the abstract map in detail onto particular features of particular services, of which there are now a great many a quarter century into the internet. And when we sort of invoke common carriage and we say, yeah, we'll do common carriage for Facebook, or we'll do common carriage for Google, or we'll do common carriage for whatever, we miss all of that rich detail, and we miss the ways in which there might be unintended consequences to that. We lose track of what we're really trying to accomplish. And so we need to do that work. Second, I think the First Amendment really factors in here. We've seen kind of a long slide towards what I think progressive scholars would regard as the First Amendment as a Lochnerist principle, right? The use of the First Amendment as a general purpose deregulatory tool. And interestingly enough, I think those have started to become echoed by folks on the MAGA right. You hear Donald Trump frequently talking about how we need to roll back, the limitations of defamation law and that sort of thing. And so I think that's led to this overreaction that we need to invoke common carriage to like just get around the First Amendment altogether. And I understand that to a certain degree, but I think there's another danger that lurks beyond that, which is, as Berin pointed out, there's real risk of autocracy when we start invoking common carriage to go after speech and on partisan grounds, as I think is kind of lurking below the surface, or not really even below the surface in the net choice cases. So what I actually think the net choice case gives us is an opportunity to say, yes, we can do really granular contextual policy analysis. We can like suss out what the expressive equities are and what we're trying to accomplish, but we need to also be respectful of the First Amendment. We need to do it in a way that avoids abuse. And I think that's the trick, right? Is kind of charting a course between fascism on one side and autocracy on one side, and Lochner on the other, and coming up with sensible regulations that deal with real problems without going too far. And I'm optimistic that we'll get there, but it's an interesting time for sure.
Thanks very much, Blake. I should have mentioned at the outset that the organization that Ben works for has done some really interesting stuff on railroad regulation, especially in the common carrier space. So I definitely encourage you to spend some time on ICLEI's website and check some of that out. And obviously, Ben has done some really interesting work in the space that we talked about as well, and with First Amendment and the common carrier. I want to thank everyone for joining us today. Roger, Ben, Blake, appreciate your time very much, and should know that the next program in this Tech in the Court series is going to be next Wednesday, September 4th at 12:30. The Feds unfriend Facebook: why FTC's Meta antitrust case should fail, which is going to include Corbin Barthold from TechFreedom in a conversation with Ben's colleague, Jeff Manny. So hope you're able to join us for that. You can go to WLF.org to register for that. Thank you again for joining us. There's going to be a short survey when you sign off, and then it launches in your browser. If you can take a minute to fill that out, those of you who attended, really appreciate it. Good evening, everyone.